When you apply for a loan or some other facility from a bank or other financial institution, you're required to secure the transaction with a collateral. Collaterals may take diverse forms, and the consequences of defaults in your facility terms are a potential realization of this security. Join our panel as we discuss collaterals today on Law Express. My name is Noella Seidu. Do stay with us.
Kwesi Austin is a private legal practitioner with a passion for reading and a strong love for football. Selassie is a legal practitioner who brings his lively spirit into every space. Outside work, he enjoys reading, catching up on movies, and taking the mic at karaoke.
Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
Thank you for having us today. I've been working in financial services for
a long time.
For a long time, almost 18 years or more.
Whoa.
Yes, and the most important thing for most customers when they think about banks is how they can get money from the bank.
Mm-hmm.
And
that's where we come.
That's what businesses and individuals think about when they when they think about banks. How can we get money from these institutions? So banks have also provided, avenues for people to borrow, and that's one of the key businesses business lines for banks. However, for banks to be able to lend appropriately, they require that these advances that they give out to their customers are properly secured. The law requires it, and prudent banking and financial management also requires that you secure these advances that you give to your customers. So one critical thing that has almost evoked a lot of passion for customers is the request or the requirement of collateral for advances by banks and financial institutions. I've heard people say that when you go to a financial institution to ask for money, they ask you to go and bring your grandmother's land papers and bring your cocoa farm and all those things. It's not far from the truth, but it's essential that people understand why financial institutions will require security before they advance funds. So collateral is anything that a financial institution would require, any property. It's either tangible or intangible. It's either movable or immovable property that a financial institution will require, to secure advances made towards the fulfillment of obligations by its clients.
Yeah. So you see that historically, banks lend, they undertake secured lending or unsecured lending. Now, since time immemorial, you'll see that there has been secured lending, except that certain events have sharpened the focus on collaterals. So, for instance, you take the global financial crisis, and then later our own banking crisis. You realize that those institutions that had collateral, that had security, that had an alternative means to recover, their money, were positioned better to stand after the crisis. I mean, no matter how positive you are about the underlying transaction, no matter how you think everything is going to go on, no matter the information that you have even about your own ecosystem, your local financial system, something can come from somewhere and then throw everything off. So then you will need that alternative which
It's an insurance.
it is the insurance that will be the distinction between whether you go under, whether your company fails, or whether you'll be standing. So as regulators, as he indicated, the regulators these days, especially after these two events that I have mentioned, have focused sharply on collateral and have rigid rules relating to collateral. And you'll see that the ratio of unsecured lending to secured lending at this point has tilted heavily in favor of secured lending, because that is the way to go. That's the way to ensure continuity and the stability in the financial system. So that's why there's talk about collateral, to start with.
Let's talk about collaterals in a generic term. What qualifies as collateral? I mean, everybody straight away starts to think of a house and a car, but I want to believe that this conversation goes beyond just those categories of property.
Yes, it does. You realize that in my earlier presentation, I said that, in my earlier submission, I said that collateral could be tangible or intangible assets, meaning that it has to be something that you could possess or something that you can't even hold, like an intellectual property right could be collateral. So you would see that in more advanced societies, people who have what they call copyrights over music, copyrights over movies, are able to use them, books are able to use them as security or collateral to secure advances that they are taking from banks. In addition to that, you could have what they call immovable property, which you alluded to at first, which are the buildings, land. I don't know if you would consider ships as immovable or movable.
They're movable.
But,
this
things
is a
like
vehicle, right?
Vehicles, and are all considered as forms of tangible security. And then there are also you could also use cash as security. So if you have a fixed deposit with a financial institution, or you have a treasury bill with another financial, or receivables, account receivables could also constitute collateral towards the fulfillment of an obligation you owe to the bank.
So in addition, so there are other assets, other things that an institution would hold good enough to lend against, like guarantees. So you have the guarantee of the personal guarantee of a director, of a third party, of another institution, itself, a corporate guarantee, which they give to a financial institution or the lender, and that gives the lender some comfort to say that I can lend you some money on the back of the guarantees that have been given. So securities can qualify. Stocks, like stuff like that. So all those things, mostly it's just anything of value, anything that the lender can hold of value and say that, okay, this gives me some comfort, this gives me some assurance or insurance, like you said. This gives me something to hold on to in the event that the loan is not repaid in the manner that has been provided for in
Mr. Wanya, you are a practitioner in the industry.
Yes.
I know you abandoned us at the bar to do this because that's where the money is, right, Mr. Austin?
Well,
I can see how prosperous the bar is looking at you and Chrissy.
But how do we assess the actual value of a collateral? So we're looking at IP rights. We are looking at stocks that could diminish.
Yes.
At the point of lending, how are you able to make projections? And even with the simpler things, you have a studio, you want to use it as a collateral. It's landed property, it's a building. Who comes to do the assessment? How is this valuation done? And how do you progress the conversation to the point where you now say this is an acceptable collateral?
Okay. So the first thing is that financial institutions would first carry out an inspection of whatever the collateral
That's
is.
where it's a tangible.
If it's tangible, even if it's an intangible asset, the financial institution will inspect whatever document or certificate covers that asset. All that will be inspected to ensure that on the face of it, it's adequate to meet the requirements of the financial institution. Yeah. Then the second thing is that the financial institution would appoint an expert who would carry out a valuation of that asset. So if it's property, you would use a licensed surveyor, land valuer, land surveyor to carry out a survey of the property and then come out with a valuation.
Check your walls, test to see.
Everything would have to be done to ensure that when the chips are down, this property would have enough value to cover the obligation that is intended, to secure. So if it's a vehicle in Ghana, what we do is that if it's a vehicle, the vehicle will have to be valued by the STC.
Yeah.
So the STC is the most recognized independent valuer in Ghana.
Yeah.
So when it comes to vehicles, so they will check the vehicle, check the engine, check the chassis, check the body, check everything about the vehicle to ensure that, if the value they attach to it can be realized when a situation arises. So when it comes to stocks, you would expect that you would use licensed stockbrokers, you would use professionals from, say, the stock exchange to be able to give you the value of the stock. And usually when you take stocks as security, because of the volatilities associated with stocks, you would want to discount the present value of that stock, and then project what the value would be in case there's a problem later.
Taking into consideration the term of the facility.
Yes, all that is done. So those are a few things that will be done to determine the value of the security. But one thing too that lenders do is you ask yourself a typical question: would I buy this asset you ask yourself a simple question: would I buy this asset at a certain price, or what price would I give for this property?
Assuming it was just in the market.
It was just in the market. That gives us, a back of the envelope idea of what the value of the property is, because that's what the market is able to pay.
That was exactly you're asking.
You're asking.
You can buy, you can take a ship as collateral, like he said. The question is, when they default, how many people
can afford
to buy the ship? So
how to buy an aircraft?
It is to dispose of it is one.
Meaning you can present a collateral, which is very valuable, but because it would be difficult to sell it off, the lender would say no.
But all that goes to the value of that collateral. You see, how quickly we can sell it or how easily it can be sold all contribute to the value of the asset. So you can have a 10-bedroom, fantastic house, it's beautiful in my hometown with a swimming pool and tennis courts and everything. You may not derive the same value from that property as you would if that property was in East Legon or in Kumasi somewhere. So the value, whether you can sell it, marketability, all that goes into the value of the property.
And you see that it has to be understood too that accepting collateral to be collateral for a transaction is at the total discretion of the lender. Now, when it comes to valuation, you'd see that practically some of the borrowers, they would come to the lender with their own valuation. They knew that we were going to do a loan, so they've done their valuation. They come to you.
They are making your life easy.
But whether you can rely on it is an entirely different question.
Because the issue is, talking about this valuation and reliance on it, every valuer will have a different value. How do you come to that middle ground? Because if the lender, like you said, the borrower comes with their valuation report, and then you do yours, and you have something probably way less than that. How do you find a middle ground? Because this is still a certified valuer who probably worked on their document.
So practically in most cases, within the setup that we are operating in, it's not really about finding a middle ground. You go with the valuation of the valuer that you probably know and you are comfortable. Yes, you the lender.
So they would always reduce the value of things to make your life easier.
Well, it's not as if the lender has told the valuer what price to put on or what value to put on the property.
But you're an expert and you know what your principal wants.
Yes.
That the lower, the better for them, because then it's easier to sell at that value.
Not necessarily. It's not as if the valuers are jaded in their opinions by what we want. No.
Okay.
They determine professionally what the value of the property is. So at the end of the day, it's just that the lender determines whose valuation they are comfortable with. So we are most comfortable with lenders that we have pre-screened, who have been in the business for a certain length of time, whose credibility we can vouch for.
In reality, even if the valuer does his valuation, it is not to say that we just pick the value, the valuation will just be picked and worked with. There are other considerations, so that you might have a value that is, it meets, in terms of the quantum, meets what you would require as collateral. But for certain other material factors, the lender can decide that I will not take this particular collateral, right? Which may not have direct links to the value that is being placed on it. But in terms of value, like he said, if you read the typical valuation report, you say that we have looked at comparable properties in the area, etc., in arriving at the value that they've placed on it. So the area, the location, and the type of buildings in that area, marketability, etc., may have been factored into the figure. And then now the lender gets that report and looks at it within the context of the transaction that it is backing, and will determine whether it would accept this or not. You can take all the boxes that you want, but if the lender is not comfortable with something that even is not in the valuation report, he'll reject it, because at the end of the day, when the chips are down, he'll say that he will have to find a way to get his collateral.
Because also, the reverse would apply, where I've seen really great property, prime areas and all, but because of some story about an incident around it, nobody even wants to buy that.
Yes.
So when you look at it on face value, this is a property on a prime land, it's in good shape, it's worth a lot, but if nobody wants to touch it because of some reputation or story,
Noella, you're right, but and that's one of the difficulties that lenders will face, because you may not know these stories. Exactly. As a lender, you may not know the history of the property. You just know that this is a nice building somewhere in East Legon or in China.
Economic sense.
Beautiful. And it's okay. The valuation is great. The location, everything is perfect. You think generally you should be able to sell it, but you don't know some of these stories. So it's one of the challenges
that was a meta scene, and now nobody wants
it. So, but we expect that the valuers would conduct some due diligence around the property, and that will feed into the value that they put on the.
It's time to go for a quick break. When we come back, we'll pick up the conversation from enhanced collateral. So you already had it at this value, but subsequently, the owner decides to make certain adjustments and enhances it in a way that probably alters the value at the time you enter the transaction, and whether that plays any role in terms of any adjustments. This is Law Express. Don't go away. Before we went for the break, I was talking about the situation where you've done your valuation, you've accepted the collateral, you have the transaction running. And then the person does some adjustments, enhancements, positive ones, that changes the nature of the property in terms of value. Does that count?
So the interest of the lender is to ensure that at all times the value of the security is sufficient to cover the loan. So if you look at most, and with this you are talking primarily about land. Yeah. Now you look at most mortgages by which land is charged as security, you'll find that there are clauses in there that restrict the ability of the mortgagor to deal with, alter, modify the property that is the subject of the mortgage. So there are clauses, like you said, it is positive. So for all you know, in the mind of the mortgagor, it is positive. But for the lender and in terms of how easy it is to dispose, it might not be a positive. So then the clause is there that whatever you want to do, discuss with me or seek my consent. And in most cases, if it is properly spelled out, it is going to enhance the value of the property. It's going to increase marketability and value. In most cases, a lender would agree that it should be done. But this should happen before. You don't alter and then come and tell the lender,
I've done this already.
That might constitute a breach that would entitle the lender to call in the facility immediately.
Because what will you do next?
Yeah, so a typical example is where I've taken maybe a 3-bedroom house to cover an obligation. And I know that a 3-bedroom house, there are more people in the market looking for 3-bedroom houses than 10-bedroom houses. Then you go and turn the 3-bedroom into a 10-bedroom hotel or guest house.
Yes.
Clearly, even though it's an enhancement in terms of the value of the property, it makes it more difficult for me to be able to realize that property when there's a default.
How do you handle a situation where there's a disaster there's a flood? You didn't expect that this neighborhood would be prone to flooding, but for some reason there's a situation that just sticks out as an outlier, and now this property, this 3-bedroom house that you have a charge over, has become flooded and depreciated in value. What usually is the banking institution's next move? Do you take it as a loss, or you would ask them to replace the collateral?
I think you've answered the question. Exactly. Where there's been no default, at the point where this act of God has happened, has occurred.
I don't know why we make it about God when
the flood is God. Once we can't blame anybody, we put it on God.
Let's give it to the devil. It's not really positive.
So once there's been no default prior to this event, we would go back to the client and ask that the client replaces the security. Because at every point in time, that advancement or that obligation must be secured.
So if he doesn't have a replacement,
then that's the challenge that,
because you can't get value from that particular property anymore. Yes. He doesn't have an extra or something else to either enhance as a top-up or to replace. So what happens to this transaction? It goes unsecured or undersecured, and you pray that he doesn't default.
That he doesn't default. I think that's it.
In most typical credit transactions with institutions, you'll find that the pledging of immovable property will not be the only security that will be used to secure.
There is another layer of insurance.
There are guarantees, or you added a vehicle, so you try and fall on these other collaterals.
Well, like we said, guarantees. So usually you take a personal guarantees of the directors or shareholder guarantees, or you would take guarantees for other individuals. So like we said, that may come into to cover some of the obligation, because if the directors do not have assets enough to cover the obligation, then only a portion of it can be recovered from the directors' guarantees.
And these days, it's very common to see inserted in mortgage agreements clauses relating to insurance, so that insurance has to be taken over the mortgage property, so that it covers
disasters like that.
Everything is covered, and at least it gives you a measure of comfort as far as the collateral is concerned.
And Kwesi mentioned insurance, and that applies to vehicles as well. So usually lenders will say that if you're using a vehicle as security, take a comprehensive insurance and make the lender the first loss payee. Yeah. So if anything happens to the vehicle, insurance
if somebody steals the car,
will pick up the tab.
Value.
Yes. Yeah.
You become the only loser in the middle.
Yes. So one of the things that, before you come in, I wanted to talk about one of the things that people consider most controversial when it comes to securities, especially the men. The law requires that if you're going to use property as security, and this property or collateral, and this property was acquired during a marriage, you must seek the consent of the spouse before the property will be used as security. In our line of work, we find that extremely challenging for most men.
Shouldn't that be pleasing to you? Because under the Old Lands Act, it wasn't in there.
Yes.
So you would find that men, and it's mostly men that go for loans when you look at the ratio in terms of the data. So men would just use their matrimonial properties as collateral, and then when they default, they come and throw everybody out and then possess this thing.
Yes.
So it was to fix that problem.
Yes.
And just for the woman to be on notice. And this consent, if your wife agrees to it, that, look, she should just sign a paper, right? That we consent to
most
this.
spouses, our experience is that most spouses, most wives
would disagree.
Do not want to sign this agreement. They do not want
But you
to
can
sign
get a
these
facility
consents.
then. Your husband
And that is
So
what
the
has
husband
been
is looking at the business side
The
of
business
things.
side.
I'm going to
picture.
get some money. I'm going to,
But
to
the
come
woman
and
is
take care
looking
of
at
you.
security.
So
But
Don't
the women
gamble
say
with
no.
our... No, how
So
can you gamble
that's
with
one of the
your,
challenges
with
that-
your
He
home?
doesn't see it to be
So
gambling.
if it fails, where do you sleep? They're going to throw all of you out.
But look at the bigger picture. I'm going to do this deal, and I'm likely to make enough money to,
Change
take
our
care of
Yeah,
us,
but
to
there
change our
still is
lives.
a chance
And I
that
just
you
need
will
this
change our
property, your
lives in the
signature.
negative.
it
When it
could.
fails,
It could
you're
when
going
it
to bring
fails.
everybody to zero.
Yes,
but is it
but-
not better,
Yes.
than having women coming in with suits claiming the property to be matrimonial property after the fact of the facility? Yes, before they wouldn't have succeeded because once there's evidence that the man consented and all of that. But in the new situation, it helps. So you avoid that litigation. Because if the spouse does not sign, you don't follow through with the transaction, right? And so you reduce the incidence of somebody showing up when you're about to probably auction the property, saying it's matrimonial property, and then it sets the entire thing back by many years.
That's true. I mean, I agree with you completely that it helps, from the point of view of the
Execution,
lender,
yeah.
it helps. But from the borrower's point of view, usually
Yeah, it
this
slows
men-
things
it
down.
slows things down for them, and they are not able to, get the funding that they need to carry out the business.
make
that
sure
they
you
want to carry
include
out.
your
The
wife.
real practical situations. Look, there are men or there are marriages where the parties keep
Exactly.
their properties separate, or they do not. There isn't full disclosure.
Mm-hmm.
So when something like this happens, it creates the situation where now it's like you have to go and disclose. That is one.
Yes.
There are marriages where the parties are not exactly on excellent terms. You see, so that communication isn't there. So
Yeah,
to
then the
get-
law is really good because that means that whatever you do, make sure your wife or spouse is on the same page as you and don't fight with them. So that when you need them to sign that paper,
They will
they
do
would
so.
sign it for you.
So yes, I mean, without belaboring the point, this is what it is. So for the
that's
perspective of a
typical
financial
thing.
institution, just to be on the safe side, you want to walk on
It's
the
just
right
to
side of
protect
The law.
the law. So
property
you
rights
would
of
require
women,
that
really.
your wife signs. If your wife will not sign, the institution
Just be
cannot
nice
accept
to your
it.
wife ahead of your loan application. This is just all it
Yes.
is. We sample people's
They'll
opinion.
give you a list of things to do.
To do
things
before.
to do, okay, if you are outside, do this.
Conditions precedent.
That's fair. Let's all negotiate his business.
But it's all good. Yes, I mean, so that is it.
We
And
sample
then-
people's opinion on this topic.
Oh, okay.
We'll take a listen, we react to that, and then we pick up from
Some of these
yes.
It is when a person is going for a loan and then you pledge with a property of yours so that the loan can be granted unto you. The bank indeed should demand collateral from people. We know the bank is a profit-making institute, a company, and therefore we've had issues where people have run away with their money without not paying. It gives them at least the known thought that I would definitely pay for my loan because I have a property of mine as a collateral with them.
I'm in a view that it has become harder for young people to accept loan due to collateral. This is because, let's take maybe for instance, I'm a graduate and I have business in mind. Because I don't have any property to use this as collaterals, I can't go for loan. So I think it will become harder for me to take that step to set up my own business or to let my dream come to pass. So I think they should put things in place to cancel that collateral things there.
Okay, so I believe there should be collateral in lending or going for loans, because I believe if you are going for a loan, you are using it for something, but then you should have something for the bank to know that, okay, this person that we are lending the loan to will probably come back and pay them or settle them. But then if you have nothing at stake, and what if you are not able to pay the loan, the bank, it affects the bank, right? So at least they should have your property, something that will prompt you that you are owing them, so you should go back and pay.
Yes, collateral builds trust between a borrower and a lender. Speaking from the view of a borrower, if the lender fails in paying or delays in paying, since I have his properties, I can keep them. And I think, yes, it builds trust because I have an upper hand in this.
So these are very interesting viewpoints. I particularly singled out the gentleman who was saying that we should cancel, or that we should cancel the whole concept of collateral. Was the lady, yes, that for young people, for instance, they don't have assets, they don't have things that they can put forward as collateral. I mean, if that system were possible, we would advocate. I mean, even the banks will go and borrow because there's no collateral, and but the collateral. Listening to other opinions, you'll see that they appreciate the fact that the bank is not in the business of gifting money, and so prudence requires that you take something in the case of a certain eventuality. And there was a case I was doing where it's as if I took the money to venture into this business. Mm-hmm. So if the business fails, then it's like you knew this business, so why are you now taking my property? But legally, the thing with collateral is that the bank is not concerned with the underlying business, the purpose for which you took the loan. The bank asks about it just to be able to assess whether the money will come back. Yeah. But whether that business is successful or not is not the concern of the banks. The obligation to pay will still hold good even if the business fails. And so that if you expected the business to give you the funds to repay the loan and it does not go as planned, then if the bank does not have collateral, then it puts the bank in a situation. And those who access funds must understand that the monies being given to them is owned by someone. It could be owned by a depositor, someone who has a fixed deposit, etc., etc. And if your business goes bad, the bank cannot call a depositor and say, you know what, the money you deposited, I lent it to A, B, C, and D, and the business has gone bad, so that should end the story. The bank will have to find a way to pay the money to whomsoever the money is due. And so, that role that collateral plays is fundamental, is important, and cannot be done away with, as some of our listeners are suggesting.
I mean, the bank is a business at the end of the day, and it will survive on trust from its clients or customers. So if people invest with a bank and they in turn invest in you, they must trust you as much as their customers and investors also do. Yes. And their ability to make sure that the value grows, and you are able to pay back your debts for their investments to also grow is what makes it a viable business as well. Absolutely. So you can expect that they sit aloof and just gift you money. How do they survive?
That's true. I wanted to make a comment on one of the things that one of the contributors said. Yeah. She talked about young people with ideas and who didn't have collateral. Mm-hmm. Unfortunately, the category of financial institutions that we are talking about, banks, specialized deposit-taking institutions, they are not designed to lend to startups. Mm. So for startups, if you have a business idea, you should be looking at a venture capital fund, you should be looking at some other equity fund, some angel investor. They have the kind of funds and faith that is required for such businesses. For your typical lender, they want a quick turnaround, money that it can give you, that you can put into a business.
With a guarantee.
That would return, and so they can pay their investors. Because most of the funds that most of these commercial banks and institutions have are short-term funds. So they don't have the patience, or what they call patient capital, to wait for you to complete, go through the ideation and then, pilot your product and then look for your customers and all. They don't have that.
For instance, if I came to you at Diamond Microfinance for a facility, you are not going to be micromanaging my business just because I came for a facility. No. It is my responsibility in absolute terms to ensure that I judiciously use this money, grow it, and pay back.
Yes.
But with these angel investors and the rest, sometimes they even sit on your startup board.
Exactly.
In a way that apart from giving you money, they literally mentor you. Exactly. Because those are usually established businessmen who have seen it all. They know that not everybody's business will survive. They believe that, but they also know that amongst probably the 10 one might do well and they get their return.
Exactly.
So they are okay to lose that money.
Exactly.
Diamond Microfinance cannot sit and lose 9 out of 10 of funds given out to people, because what would the board say and what will your investors say?
Exactly.
The regulator say.
And the regulator, they're going to take over.
That is what happened to a lot of institutions that collapsed or that were resolved during the banking crisis of between 2017 and 2020. You know, a lot of institutions, you know, microfinance institutions, savings and loan institutions thought that, you know, we could invest in ideas, we could invest in people, and doing that meant not taking collateral for some of these loans because these people didn't have properties or any assets to put up. And when those businesses did not take off, it's not as if they even failed, they did not even take off, the bank or the financial institution was left holding the bag.
It was a simple thing of take the money, they don't even start. So what happened to the money?
I mean, at the end of the day, it was going through the ideation process, you know. They are now thinking about it. They are now looking for customers. They are now trying to design even their product, test the product.
They were spending.
And that's what happened. And you hear this happening to a lot of startups. And for the venture capital funds, like you said, they are okay to lose $10 million, $50 million.
Because one idea can give them a lot more.
Give them a lot more. So they are designed to be able to do things like that, and they will not require that you put up any security, any collateral at all. So for the young people who are listening to us, who have ideas, who think that their ideas are winning ideas, there are a lot of funds out there, you know, that they can look to help them raise the funds to be able to push their ideas and bring them to the market. So they should look for venture capital funds. I think in Ghana we have some angel funds. We have the Ghana Venture Capital Trust Fund, and a few more Ghana, that you can.
I mean, you just have to do proper research.
Exactly.
And then it would help.
Yeah. As far as incidents relating to collateral is concerned, he's mentioned, you know, this the spousal consent, etc. Now, it's important to appreciate the nature of collateral. Okay. Now. This has been the subject of the BOG's comment in their, you know, financial literacy. They mentioned it, that when you pledge an asset as collateral, it is not the case that by virtue of using that asset as collateral, the ownership or title must be transferred from you to the institution or the lender. It is not a transfer of assets. The institution is only creating a security interest in that asset. The asset will remain your asset. It is only upon failure to observe any of the obligations, payment obligations or some other obligation that will constitute default, that security interest will be realized, and title can, if it is realized, pass directly to the lender. So you'll see that in the past you could go for a facility and they would put before you a deed of assignment.
Especially for cars, they do change of ownership
or
immediately.
From C to change the ownership. Yes, and the Bank of Ghana is saying that is wrong. The title to the asset should not pass. It is only the security interest that must be created and that attaches to
So
the...
you rather put a charge on it.
It's the charge.
You register that charge with the Bank of Ghana Collateral Registry, and that is enough notice, right? And also with the Lands Commission and all the relevant entities.
Registries. If it's the property of a company, you're required to also register it at the company's or the register of companies as well.
So that there's notice to everybody that when you're dealing with this property, you should know that there's a charge on it. But it now doesn't become the lender's property.
No. Yes. And one of the things too is that, you know, that the security interest is limited to the obligation owed to the lender. Yeah. So it's not the entire property that the lender, once I sell it, I take all the money. No.
So your interest is to the quantum that is owed.
Owed to the person.
So if the property is, say, $10 million and the
Bank of
the
Ghana are not like
facility.
that. You're mentioning $10 million in Ghana. So say
In this city,
10 million cities.
Okay, fine. Let's do this. If it is 10 million cities,
Yes.
oh my goodness. And the facility is just worth 1.5 million, and with all the extra incidental costs, say 2 million cities.
Yes.
But that is the collateral. So your charge,
It's
the value
limited.
is limited to the 2 million,
Yes.
which means that you can use the same property as collateral in another transaction, perhaps which could be worth 3 million cities.
That is true. I mean, so financial institutions would usually can't hold property, lend jointly, hold
the
security interest in the same property.
We'll
And
go
you
for
mentioned
another break.
Okay.
When we come back, you can take it up from that.
Okay. So it's important for providers of collateral also to know the restrictions that exist as far as dealing with the collateral after you have sent it. Some people feel that, well, if I put it up as collateral, well, if I rent it or I sell it off, I get my money, I walk out. The bottom line is that the collateral is effective against these third parties. So buyers of property should beware. When you're buying property, you should be careful that...
Do due diligence.
Because even if there are instances where the sale can be recognized, but it will still be subject to the mortgagor's rights, so that the obligation to pay the loan will still remain with the borrower if he sells the property without the knowledge of the lender, which, in fact, in most mortgages, there will be a clause barring any sale. But supposing there wasn't and the transaction went on, if the borrower pays off the loan, then the new buyer, the mortgage dies off, the new buyer is okay. But if the borrower does not honor his payment obligations under the loan transaction, then it means that you, the new buyer, you bought the property or that collateral together with the charge that exists on it.
You bought it with a baggage.
Yes.
It's encumbered as at the point of acquisition. And so you might find that your rights will be subservient to the mortgage
Unless you're
rights.
willing to pay off that.
Pay off and keep your property.
Perhaps if you're lucky and you haven't paid all the money, then you could use that
as
to pay it off,
so that you can keep the the property. But it's never pleasant to realize that the transaction that you are in is the subject of a mortgage. So in terms of the procedure, the law has come up with the Borrowers and Lenders Act, which it works both ways. It provides some positives for the lender and also provides some positives for the borrower. So for instance, this requirement of serving on you a pre-agreement truth in lending statement is something that inures to the benefit of the borrower, in that it's supposed to make sure that you are front-loaded with all the relevant details regarding the facility. In fact, one interesting feature is expressing the interest rate in a manner, standardizing the interest rate so that interest rates can be funny. It can be expressed yes, API. It can be expressed in a manner that to a lay person you might think that this is cheaper, but in fact it is more expensive. So they are compelling lenders to express it in annualized form, in standardized form, so that when you pick truth in lending statements from 3 institutions, you can just look at the figure and it will tell you which is more expensive, and that is a requirement. And any terms that are not included in that statement can be held to be null and void. They will not operate against you. So these safeguards are given to the borrower. And then on the flip side, I mean, over time, for the lenders, we've complained about the court process, the realization process, because for some financial institutions, 1 year can be the difference between you being a going concern and you failing. 1 year with tight liquidity and you can go. Exactly. So if we have a system that does not enable them to, financial institutions to convert this collateral into cash so as to meet their liquidity demands, then more or less the financial institution is being put in a very tight situation. So that procedure to realize without a court order, gone are the days where you think that, court will take 3 years.
Yeah,
and
yeah.
so anything can
Just
happen.
sue me. So they default
Sue
and
me let's
expect you
go.
to start.
Yeah. So now this act has made it possible for lenders also, once they have finished you with all the information and you've taken the loan and brought the collateral.
But people in litigation can always find
But
ways to
yes,
put
that's
spokes
what I was going to say.
in
That,
there
but we
to
see
put
you, the lawyers.
sticks
Okay,
in-
in this
sticks in
case,
your-
I'm not.
sticks there.
In
You are
this
a
case,
lawyer
I'm
too.
not
a
a
lawyer.
I think
lawyer.
when he chooses
I'm
to
not
just
speaking
be
as a lawyer. I'm
somebody
speaking
in a
as a
financial,
banker.
oh, you see,
As a banker, in
Industry man.
this is what the bankers take advantage of this very beautiful provision that has been created to make things easy for the banks. The lawyers have found ways to turn the whole thing into a song and a dance. It can take 4 or 5 years,
We're
the
just
same
acting
length
in
of
the
time
interests
it
of
would
the
take
clients,
to regulate.
because you're the stronger
The
side.
thing is that I think that the courts have to take a position on, the realization of security, because it goes to the heart of what financial institutions do. We have to create a special procedure for the realization of security. Because if we're going to go the way the lawyers, we are just going to go back to what was existing before this law.
No matter what you
That is
bring,
the situation in which we have found ourselves.
The current legal,
regime
that we have creates procedures by which you can avoid a full trial. So if you think you have a good case, you go under summary judgment. If you think the case against me is frivolous, you go. Oh no!
The judges are very reluctant to grant these very quick
attitude sometimes. Because yes, they are reluctant because they feel
they
that
need to err on the side of caution.
They feel that if they take you away from the seat of judgment, they don't let you have your day in court. It's like
they assume that the financial institutions are more powerful.
But Mr. Austin, there are ways to go
borrowers.
around it still. It's all about the industry of the lawyer, if you ask me. Because there are many ways to go around it, especially where your client's case, that is where you are representing the lending institution, is ironclad, their paperwork check out, the notices that are required to be put out there are all put out there.
So
where that wife shows up from nowhere to issue a writ, you know what to do to get it out.
You mentioned wife, right?
If the lawyer really wants to waste your time, the three of us know. If you issue a writ for fraud, you know what happens. So there are ways.
We've been in court. I'll give a typical example.
The man is upset about that aspect of the law.
We've been in court for, I think, since 2018 on a matter where we went under the lenders and borrowers. What the client did was the lawyers just issued a writ, filed an injunction, and we've been in court since then. So it just takes us back to the pre-Lenders and Borrowers Act situation. The lawyers have taken us back there. So we've been in court on this matter
you must admit that this new
7 years.
dispensation, a new legal regime, still makes it easy in some instances. It's not all bad.
Oh yes, I mean, if
compared
I
to
will not admit
if it's had
or agree
10
to that.
facilities go bad,
Yeah.
maybe 3-4 he's been able to recover.
Exactly.
So then there has been some utility. So it's up to the courts maybe to look at it carefully and
there've been
provide
discussions
higher thresholds
about specialized courts, like how we used to have the fast track system, just to handle matters under the Borrowers and Lenders Act, and to just see that, and they should have some time period within which these matters should close. So these have been conversations at the recent stakeholders event by the Bank of Ghana for collateral registry. These were some of the ideas that were pushed forward. And I think that the right people should listen. And as a Ghana Bar Association, we could push it. But yes, the bankers, association, they should also talk about their challenges, because for us lawyers, the longer we drag it, the better. The bar must prosper.
The more money you make.
The bar must prosper. But Mr. Wanya is not happy because he abandoned the bar to go and lend the money, and now
and then the lawyers are frustrated.
So just come back to the bar. We have some questions that have come in. Let's try to answer.
I do not own a house, but I have a farm. Would that be acceptable collateral for a loan for my business? Also, how do I ensure that the actual value and not a diminished value of the property is used in a possible transaction?
think when we itemized the various forms that collateral can take, we listed, or Selassie indicated, immovable property. So clearly, a farm, if it's the farm that we all know, a farm would fall, because it is land, would fall
especially
within,
with cash crops.
you know.
But if you,
But-
the way
but yes, because he's imagining if he gets an application and the security is
Mango farm.
so you'll be
will
more
you
interested.
take that though?
Well, the question is it the produce or the land?
The land.
What are you bringing?
but
What
I
I bring,
found
or
that
is the
lately
composite value of the mango
lending-
trees and the land. I don't
lending
know.
institutions are shying away from bare lands.
Well, because of the dispute, etc.
Exactly.
Because when land is bare, it's difficult to establish. It's more difficult to establish possession and ownership. But hopefully, with a farm, you would have planted as evidence of your control and ownership. So it is something that.
So does the type
they
of
can look at.
produce also matter? Is Mr. Wenya more likely to accept maybe palm plantation
or
compared to
teak
a pawpaw
plantation.
plantation?
It is more likely if a financial institution is forced to take security, and the only security the financial institution must take is the borrower's land. It is it is possible that the financial institution will be more comfortable taking cash crops, farmlands that are were cultivated farmlands.
Okay.
And the cultivated farmlands should be high value cash crops, maybe like rubber, hardy, cocoa,
Coffee.
teak, plantations, but not pepper or maize or
Cabbage.
That
or
you come
cabbage
next week and
farms,
tell you
or
that the farm is
some
destroyed
rats
by-
have come to eat the plants or the fruits. So
No, don't look down
but
on
I think
these
it's a very
vegetables,
difficult.
guys.
It's a very difficult area, agricultural lands. Especially issues of ownership, like Kwesi said. Most of these lands probably owned by communities, by stools, and so
You've just been
determining
asked to farm.
Yes.
Yeah.
So somebody is just a tenant, and has been a tenant probably for over 50 years. The entire family has been
There's some
farming on
people
that land.
presume they own it,
own
and if you
it.
do due diligence, it's for them.
It's for them.
Until it's time to now take possession and then
Exactly.
sell.
Then
Then the
have-
chief comes there to
comes
say, "This is."
Exactly. So it's farmlands, is a challenge, and you see that very few financial institutions in Ghana, would
But you
accept
see, this is
farmlands
why
as
there's a
security.
challenge raising capital for people in the
Yes,
farming industry.
yes, yes.
Because how do you now? What else do you have to put forward? If you don't have other equipment, maybe tractors and all of that, what do you do?
So again, there are specialized institutions like banks. ADB is it's supposed to be an agricultural bank.
Yeah,
for
but they
instance.
still need a
So-
collateral.
Yes,
at the end of
so
the
they
day.
should be more disposed to appreciating the circumstances of the farming community, and design products that will suit.
So what you're saying is that if you're a
Yeah.
farmer, it's better to look that way. But if you're into business or other loans, then you come to Diamond.
Yes. If you're into business, yes,
Come
you
and
should
see
come.
Diamond.
I mean, but the
Fine.
thing is that less farming is also business. I think that
Yeah.
it's business,
Not to say-
and so the solution lies with our authorities. We should be able to complete this whole land registration process that has dragged on for decades.
Forever, yeah.
I know we have done lap 1, we are now lap 4, lap 3, and we've been trying to do registration and titling of
The
properties for a
entire-
very long time. So if our authorities want us to be able to lend against farmlands or provide lending to farmers, one of the things we need to tackle is land registration. We need to ensure that we can register all the farmlands
But you sound like
properly,
land
and,
registration in itself is all it takes. There are all manner of multiple registrations. There are all manner of disputes that even with a well-registered land, you can still have issues coming up later.
No, Emmanuel, so
but that
those
was
things are bottlenecks or hindrances that you would encounter in the registration process. But let there be the system. Let people be able to start registering and even face these challenges and resolve them so that there's clarity provided as to who the owner is. At the end of the day, once we're able to get to the point where it's sufficiently clear who owns what. When you are accepting farmlands, you do so without that, having any, doubt in your mind as to who it is. So that system is absolutely critical. It is necessary. So he's asking, how does she make sure that the valuation used by the lender is the correct
and
value?
not a diminished value.
Well, like I indicated earlier, the whole business of collateral, its valuation, its acceptance, it's at the discretion of the lender. It's about what the lender feels makes him comfortable. So, for instance, there's a collateral cover. For instance, the value of the collateral is 120%, should be about 120% of the value of the loan and the facility, the loan. And so, at the end of the day, again, it boils down to what we said about there being a valuation. So you have in your mind what your valuation is. We don't know, or the lenders don't know what prejudices informed the valuation that you've put before them. And so they need to satisfy themselves as a lender, because when the chips are down, like you said, it's the lender who faces the music. So the lender has to satisfy itself that the value.
I mean, it's only fair. At the time that you're looking for the loan, you are even so desperate. You do anything the lender asks. And if the lender now says this is the value, if you really in good faith know you're going to service it, you shouldn't be worried.
You shouldn't be too worried.
Because in the end, it's still yours.
It will be your property.
If they say it's lower, that's their problem, right? Just make sure you pay up.
That affects the amount of money the borrower
can get.
Access. Yeah. So I think that's the point. That's another point that the questioner was making. That so the real value, like we said, if the value is enough, if the valuation is enough for me to be able to borrow what I want, then I wouldn't have any issue. But where the valuation comes to is diminished and is so low that I cannot even
get what I
borrow
want.
what I
but
want.
But the true value is more.
Higher than that. Then I think that this is a contract, right? This lending and borrowing agreement or the credit arrangement is a contract. And there are so many negotiations that go on before the agreement is signed.
Options.
So the borrower should negotiate with the financial institution
to get a fair value.
That they could even protest that the valuation, they think the valuation is too low, and so they would want another valuer to offer or prefer a second opinion.
It's been a great conversation, gentlemen. I had fun. I don't know about you. Would like to thank the boss from Diamond Microfinance. I don't know. Are you still a lawyer?
DCI Microfinance.
DCI. Are you still a lawyer?
Yes.
Because you ran away from us.
Role of lawyers.
You ran away from us.
I'm the role of lawyers.
Pays dues on an annual basis. Yeah.
It's been great, gentlemen. Viewers, I was joined today by Mr. Selassie Wenya and Mr. Kwesi Austin. This has been our conversation on collaterals. My name is Noella Seidu. Until next time, this has been Law Express. Goodbye.